Next case on the court's calendar is KPMG Peat Marwick versus National Union. Mr. Brown.
Yes, sir. May it please the court, Louis Brown and Diane Feinberg of the law firm of Gilbride, Heller & Brown, Miami, for the petitioner KPMG Peat Marwick. The question certified is by the Third District Court of Appeal is whether this court's 1934 decision in Danler Lumber versus Colombia Casualty is still good law in light of this court's 1997 decision in Forgion versus Dennis Parle. The question must be answered in the negative. Danler is no longer good law to the extent that the opinion approved of the transfer by subrogation of an accounting malpractice claim.
Would you give us, to begin with, an understanding of the factual pattern that this case came to the district court in? I understand it was on a matter of pleading. Is that correct?
It was a motion for judgment on the pleadings. It was granted, and final judgment was entered by the circuit court.
Okay. Now, this is on a Fidelity bond?
Yes, sir.
That was the subrogation instrument, correct?
National Union Fire Insurance Company was the blanket bond insurer for Bank Atlantic, a federal savings bank. And the claim was made that the bank had suffered approximately in excess of $20 million in losses due in part to wrongful conduct on the part of employees of the bank, but also an outside fraud perpetrated by a New York company who was selling indirect consumer dealer paper. The bank bought approximately $60 million of that paper over a 3 or 4 year period. And 1990, prior to 1990, KPMG had been the auditors, accountants, tax advisors to the bank for many, many years.
And so the allegation of the amended complaint was that the audit had been performed in such a way that the result had been a loss, there had been a loss by Bank Atlantic for which the bonding company responded, and therefore it took the rights of the bank against the auditor. Is that correct?
Yes, Your Honor. What happened was initially when the bank made a claim against the bonding company initially rejected the complaint, which resulted in a lawsuit being filed by Bank Atlantic in federal court in Miami seeking to enforce its rights under the policy of insurance. The primary loss was caused by wrongful conduct on the part of the New York company Sterling and allegedly certain employees of the bank. At the time the settlement agreement was negotiated, it's in our appendix, it's styled a covenant not to execute. The bank and National Union entered into an agreement pursuant to which the bank agreed in its own name to seek recovery in what is traditionally called salvage litigation against various third parties. However, that settlement agreement did not provide for the bank suing its own auditors and accountants, and my client continued during that period of time and continues to this day to be the accountants and auditors for Bank Atlantic. What in effect the settlement agreement provided, and I think quoting the language is very important to understand the position both the bank and its auditors find itself. The paragraph reads, "The investigation by National Union of its exposure in connection with the BA bond claim has caused National Union to believe that Bank Atlantic may have a claim against its auditors, KPMG, for breach of contract to the extent that the acts or omissions of KPMG may have contributed to Bank Atlantic's losses." That provision goes on to provide that in connection with the carrier's investigation of the claim, that the bank agrees to share otherwise privileged information with the carrier, And the agreement provided that that would not constitute a waiver of the privilege, but the privilege would continue to apply.
For purposes of the issue, though, that we have before us, don't we have to assume that there's liability of your client extending to the bank?
Yes.
Not that there is, or whatever those, and as opposed to dealing with this particular case and its facts and circumstances. So we assume here, do we not, that the bank had a cause of action or has a cause of action that could be assignable, in the first instance in order to decide that question. So this,
yes,
this is really collateral, is it not, to the issue that we have about assuming that there is a proper cause of action of whether or not it's assignable. Is that?
Yes. I think the importance of the language that I quoted from the covenant not to execute is the fact that the bank had agreed to pursue causes of action against all third parties, but apparently in the course of the negotiation of this agreement refused to pursue a claim against its own auditors. And in turn, the carrier was the one who thought a claim perhaps might exist against someone they could pass on some of the responsibility of paying under their insurance.
But that's going to be quite another issue, or would be, assuming that we decided it was assignable, of whether or not they could prove up a claim.
Correct. The central question before the court today is whether or not, in light of the 1997 decision by this court in Forgion, where the court reiterated the holding that personal tort claims cannot be transferred to a third party, the courts in this state, including this court in Forgion, recognize that claims by clients against attorneys cannot be transferred because of the personal nature, the confidential nature of the relationship. Under the law in Florida, the same privileges and confidential treatment of the relationship between accountants and clients is the same as it is for lawyers.
Well, the reason I'm was interested in the underlying action is to really get into the discussion of whether an independent audit, which I understand is the focal point of this cause of action, is different than the type of normal CPA relationship with a client that's preparing some type of financial record or tax return. Isn't that different?
Your Honor, there is no question that the allegations in the amended complaint against KPMG was that there was negligence in conducting audit of the bank. The KPMG, there's no question, were and are the independent auditors for Bank Atlantic. But that is the posture taken in adopted by the Third District in its opinion, which is before you, and also the position taken by National Union. I caution the court, if you head toward a task-based analysis of whether or not a particular claim is transferable, you slide down a very slippery slope, because in the law, lawyers oftentimes render services to public clients that have the same exact type of public attributes that the performance of an independent audit, for example.
Well, for instance, signing some type of prospectus that goes to the SEC. I would assume that that's what you're
a municipal bond lawyer who writes an opinion to the public about the tax-exempt status of a particular municipal bond offering. What you have to look at is the expectation that the client has when they enter into the relationship. I urge the court not to take a task-based approach to determining whether or not a particular claim is assignable, because then there has to be, in many instances, an invasion of the accountant or attorney-client privilege merely for the professional to begin to raise a defense that the type of claim that was transferred shouldn't be transferred in the first instance. Does the accountant...
Is it important that in this case, of course we don't have if it was decided in the pleadings, but that you mentioned that your client was not only the independent auditor, but also performed multiple functions, including tax advice? And are you suggesting that these all become intertwined when you're evaluating the reasonableness of the conduct in this?
Let's take a different for instance, because although KPMG is before the court, in truth and in fact, every accountant in the state of Florida is before the court. As we've indicated in our brief, audits of public companies is one of the smallest percentages of the type of business that most accountants and accounting firms in the state of Florida perform. In fact, in KPMG's case, as we indicate, approximately 20% or less of the total revenues of the national accounting firm are derived from audit function. Typically, even if an audit were being conducted with a small business owner, when that small business owner walks into the office of his accountants, no matter how big or small that accounting practice is, and he begins to talk about his business planning, tax advice, how's the audit going, his mind is not shifting between what he believes to be an otherwise privileged conversation or what is or isn't a personal relationship with his accountant. Typically, it's oftentimes difficult for someone to understand what an auditor does when he plans and performs an audit. In the planning phase of an auditor sits down with owners and management of a company, discusses with them what their business results have been for the prior year, what types of businesses and business strategies they're undertaking going into the subsequent year, so that the auditor can identify what are typically described as critical audit areas over which they should apply more detailed attention. Likewise, during the performance of an audit, a management letter is typically written by the auditor explaining to management of the company various issues that he sees that may be a problem in future years that may impact on their ability to report accurately in their financial statements. So despite the fact that we may issue a report and opinion on the financial statements of a company, there is a tremendous amount of confidential, otherwise privileged information that is exchanged between the accountant, the auditor, and the client. It's also important to understand that the cases relied upon by the Third District and urged by my able colleagues are principally U.S. federal law. The Third District relied heavily on United States versus Arthur Young. We must understand, in federal law, there is no accountant-client statutory privilege. In Arthur Young, it was an action brought by the Internal Revenue Service under Section 7602 of the U.S. Code, undertaking an investigation regarding taxation. What the United States Supreme Court said is we need unambiguous direction from Congress if we are to parcel out some sort of judicially created privilege. What happened there is that the Second Circuit Court of Appeal took it upon itself to attempt to create a common law accountant work product privilege that didn't otherwise exist or be recognized under federal law, and of course the U.S. Supreme Court rejected it.
Well, is that what is that the hat or the peg you're hanging your hat on? That is that there's the statutory privilege, or that the nature of the services are very personal and interrelated and very similar to what an attorney might do in rendering advice, and that's the analogy we'd be looking to.
Well, I think one created the other. The fact that the legislature, and indeed this court, when it adopted the evidence code to the extent it was not in conflict with other rulings of this court, and therefore embraced an accountant-client privilege, along with, I might add, attorney-client privilege, psychoanalyst patient privilege, domestic violence counselor and client, that the legislature and the court looked at these relationships and said these are relationships that individuals view as being personal and have an expectation of privacy. Noting that, the legislature enacted and the court adopted a privilege protecting that relationship. So I think one, Your Honor, goes hand in hand with the other, and therefore the exact same policy considerations that had led the Fourth District in the Washington case to say that lawyer malpractice cases were not assignable.
Is there anything that, assuming that we decided the case in your favor, is there anything that would prevent insurers from putting conditional language in their policies that mandated as a condition of the policy that the insureds bring actions against other parties that may be liable for the loss that the insurers are paying, and therefore, in essence, doing an end run or doing the same thing, but in the way that years ago many policies were written, that is, the insureds, bringing these causes of action, or the insurers bringing them in the name of, or the insureds bringing them for the use and benefit of the insurance company. Is there anything that would prevent a company from doing that?
There would be nothing to prevent, of course, they're drafting that type of language into a policy. I would suggest that such a clause would be, in essence, an abdication of control by the client over the very personal relationship that the rules of law regarding no assignment and no transfer by subrogation is designed to prevent.
Because you're not arguing here that as we established before, that the client, the insured, couldn't bring a cause of action. against your company?
Absolutely not. The client can sue for malpractice if the client believes there's a basis for it, but oftentimes because of the lengthy time period of the relationship between a client and a professional, the fact that they've shared information over the years and become familiar with the business, the client is in the unique position and should be left to decide whether or not strategically it's appropriate for them to compromise that relationship, to break the relationship, and initiate legal proceedings and in the process waive a very valuable privilege. I think that's a decision that the court should leave to the client in what has been recognized to be a personal and highly confidential relationship.
Isn't that decision made when they, if the client chooses to assign those rights? Why isn't that the answer to that question? When a client decides that although they're personal rights, I'm choosing to assign it because I don't want to have to be bothered with the litigation, and my insurance company is willing to pay the money, then what's wrong with that? What's the policy that prevents something like that from happening?
It's the same policy that this court has adopted in citing with approval intermediate appellate courts' decisions in this state that say claims against attorneys cannot be transferred voluntarily, because the same argument can be made that the client knows he's waiving certain privileges, that the privilege is going to be invaded, but yet he decided to sell his claim to somebody else against his own lawyer. What the courts have said, and I'd cite to the court the affiliated Florida versus You Need Sundries case out of the Second District Court of Appeal, where they stated that it was the public policy of Florida not to allow a client to consult with an accountant or attorney without fear that the resulting communications may become public. And so in order to protect the personal nature of this relationship, the courts in this state, including this court, have uniformly held that the public policy issues outweigh the particular right of a client to sell a claim against a lawyer.
Well, isn't that different than this situation? Aren't we dealing here with equitable subrogation principles also? In other words, when someone pays the actual debt that therefore the client would have otherwise pursued, that they stand in the shoes, and that's different. The policy is very different there than just saying I'm going to assign my personal torts or my actions against attorneys just because I want to sell them to somebody else. Don't you see a difference when it's the insurance company actually paying the loss, that because you have not only the contract that guides and provides subrogation, but you also have equitable principles, that alone should allow National Union to pursue these rights?
That same argument did not convince the Fourth District Court of Appeal in the National Union versus Salter case when it found, consistent with opinions from other states, notably California, that the transfer of a claim, be it by assignment or subrogation, is no different. And in fact, I caution the court that in private situations, which I also might add, that despite the fact that there's been an argument that the public attributes of an independent auditor militate against the rule that we urge, very rarely, if ever, are you going to find public attributes associated with the transfer by either assignment or, for that matter, subrogation between an insured and an insurance company. It's purely a private dispute. And you run the risk of potential for economic coercion with a carrier demanding the transfer of a right to sue a professional when the client who paid for a policy of insurance deserves to be paid on his claim now is faced with a situation where he can't get that money unless he gives the insurer a right to sue his lawyer or accountant. And the court, for those public policy reasons, in the National Union Salter case, the Fourth District said, no, you cannot transfer by assignment or subrogation. I'm going to save the rest of my time for rebuttal. Thank you.
May do so. Mr. Crowder.
May it please the court, my name is Russell Yeagle. I'm here with James F. Crowder. We're with the law firm of Kimball & Hayman. We represent National Union. I'd like to point out to the court first off that with respect to the factual issues, National Union was both an assignee and an equitable and contractual subrogee in this case. The covenant not to execute specifically provided they would assign their claims to National Union. What's also important about that covenant is that it addressed the accountant-client privilege. Justice Parente, one of the questions you asked opposing counsel was whether or not they were hanging their hat on the privilege. And the answer is unquestionably yes. Historically, courts in this country have refused to allow the assignment of legal malpractice claims primarily for three reasons. The first one is the fiduciary relationship between attorney and client, the undivided duty of the attorney owes to his client. The second has been the confidential relationship between attorney and client. And the third one, though the courts have said it's been a limitation on substitution, I believe that I will demonstrate the court also relates to the fiduciary relationship. When opposing counsel was discussing with you all of the other services that accountants provide their clients, you never heard the word fiduciary relationship. You never heard the words undivided duty of loyalty. They suggest to this court that the third district inappropriately construed prior law and said public accountants owe a duty to third parties. That's not what the third
Well, the
district
legislature
did.
didn't draw that distinction, though, in making the accountant client privilege the same as the attorney-client privilege.
Justice Wells, the privileges on their face are the same, but historically what courts in refusing to allow the assignment of legal malpractice cases have not focused on the confidential communications, they have focused on the duties that the privilege serves. And speaking of that issue, if you look at the case of First Community Bank and Trust versus Kelly Hardesty and Smith.
Would there be a difference in a situation in which we were dealing with a public offering and the lawyer signed the papers to get the filing before the SEC, as did the auditor, and there was an assignment of that claim? Would it make sense that you could have a subrogation claim against the auditor, but you couldn't against the lawyer?
Well, I think unquestionably, because in the context of the SEC, the independent auditor has a duty to disclose illegal acts to the SEC, which again goes directly to
What is the lawyer's
issue.
responsibility as far as
The lawyer
the
has an
SEC?
undivided duty of loyalty to his client.
And so the lawyer doesn't have any obligation in signing those papers
He has
to the public?
He has an obligation, Justice, but he doesn't have an obligation to disclose confidential communications to the SEC if he learns of acts that his client has done. The independent auditor, by SEC standards, must disclose certain illegal acts. Now, granted, there's a process. They must disclose them to the board of directors first, et cetera, but that goes directly to the issue. Historically, what the courts have focused on is this fiduciary relationship. In Piccadilly,
Couldn't you equate the lawyer's duty as an officer of the court? He has certain duties that he owes that could conceivably conflict with the interests of his client as an officer of the court, knowledge of a crime about to be committed, for instance. So other than that facet, that the lawyer is an officer of the court, the confidentiality and so forth, aren't they the same as to the lawyer and the accountant?
not at all.
Doesn't the accountant owe confidentiality other than in a limited situation?
No, Your Honor. As the court explained in First Community
He
Bank.
can just go out and talk about his clients?
No, Justice, he can't talk about his clients, and he can't talk about the information. But the question is, what duty does the privilege serve? The duty of the independent auditor, its only intrinsic value is to the client itself. Most states do not have an accountant-client privilege. It doesn't preclude the independent auditor from performing services. The lawyer, on the other hand, has duties separate and apart from the duty of confidentiality. And that's exactly what the Indiana Court of Appeals said, and why they said no. The same exact argument was made in that court. And they said, no, the privileges on their face are the same, but they're fundamentally different because the lawyer has a duty to be a zealous advocate of his client. And therefore, the duty of confidentiality serves the attorney-client relationship. It just doesn't serve the client's own interests. Therefore, if the client wants to waive that accountant-client privilege by an assignment, like it did in this case, it can do so.
Would the same argument apply to an in-house auditor as opposed to an independent auditor?
I don't know that I think the in-house auditor, by virtue of the Florida statute, would even have a privilege. The privilege specifically provides to certified public accountants and public accountants performing, and something I'd like to point out to Justice Parente, accounting services. there's a lot of question about how much now of the broad scope of services that are being offered by the large accounting firms, how much of those services would even come within the ambit of the privilege in the first place.
And just wait till we get multidisciplinary regulation.
You know, Justice Parente, that's an interesting point that I'd like to address, because in their briefs, what KPMG is effectively asking this court to do today is to say lawyers are the same as accountants. And they say we even have similar ethical responsibilities. And yet, when the American Bar Association put out its report on multidisciplinary practices, the AICPA took objection to the imposition of the legal rules of ethics to MDPs, stating that it would create conflicts of interest where none existed before. And yet KPMG comes to this court today and says, well, we're really the same. We're not the same. Lawyers are advocates. They're an extension of the court. They have a duty to be a zealous advocate of their client. They have an undivided duty of loyalty. CPAs do not have that. You've not seen KPMG sit up and say this court, and you didn't see him say to the third district, that we owe a fiduciary relationship, just like lawyers do. They won't say it.
Are you asking us to broadly say that all accounting malpractice causes of action are assignable, or only those that arise out of independent audits? In other words, this question of this task-based analysis, which I think could lead to this slippery slope that your opponent suggests. Is that a concern, or are you asking us to go much broader and just say if it's an accountant and no matter if it's tax advice, independent audit, it's assignable?
Judge, I don't know how slippery of a slope I really think that is. The simple answer to your question is we're asking this court to address the facts of this case. The facts of this case are that they have assigned a claim against their independent auditor. We're not asking the court now to rule on what's going to happen if there's a tax claim. And it's difficult for me to envision a factual scenario in which that would even happen. Is the state of Florida going to start accepting assignments from taxpayers to go against their accountants for improperly preparing their returns? It's kind of hard to envision that type of scenario. But no, we're asking this court to simply look at the laws that exist. It's important for this court to know as well that you'd be the first court in the country to rule this. Every other court that has even remotely gotten near this issue has said, no, we see no objection. And many courts have relied upon this court's decision in Danler Lumber and Export Company. I'd like to again go back to the issue of the undivided duty of loyalty and the breach of the fiduciary relationship. One of the things that the courts have pointed out in the legal context have said that if a lawyer knows that his adversary can buy up a claim against him, it may chill his duty to be a zealous advocate. And therefore, he may not be quite a zealous advocate for his client out of fear that when the litigation got nasty, the opposing side may come after his client or work a deal with his client and take an assignment so that the lawyer is now in the awkward position of having to say to the client, yes, I advise you to go ahead and settle this case and give them a legal malpractice claim against me. So the courts have focused on the chilling effect that it would have. The AICPA focused on that same chilling effect in its professional pronouncements. It said in situations where an insurer is subrogated to the rights of the client to come after the CPA firm, the situation is not normally impaired. So we have a direct contradiction. All of the policies that are before this court and what has always precluded legal malpractice claims from being assigned have dealt with the chilling effect on the lawyer-client relationship. And the AICPA says there really is no chilling effect except in limited circumstances where there may be an allegation of fraud against present mismanagement. I like the case of United States versus Arthur Young and Company because the court focused on that case on the public responsibilities of the CPA. And it said that ultimately the CPA owes its fidelity to the public trust. And what was also interesting about Arthur Young and Company was it again dealt with the chilling effect and the privilege aspect. The chilling effect, the concerns were that a client would not tell his lawyer, give him full and frank disclosure, thereby limiting the ability of the lawyer to give frank legal advice. In the United States versus Arthur Young and Company case, the circuit court also indicated we have concerns that people may not be full and forthright with their independent auditor. The Arthur Young Supreme Court said, however, No, there's a countervailing situation, which is if the client doesn't tell the CPA, the independent auditor, all of the information that's necessary, then the independent auditor will give a qualified opinion. And by no means does a public company want a qualified opinion, or even that's the case of a private company that's going to a giving a loan, because it's going to be red flags that the company has a problem. And so there's a countervailing situation that won't cause any chilling effect if we allow or refuse to recognize this privilege as what they were doing at the federal level, and that same situation occurs here. Bank Atlantic is a public company. And so there is no countervailing chilling effect because it's going to be Bank Atlantic will have to be full and frank with its independent auditors, otherwise it may receive an unqualified opinion or a disclaimer of opinion which would devastate it. So again, the policies which courts have historically cited as the reason why we will not allow the assignment of a legal malpractice claim are not here today. KPMG is simply saying to this court, in Forgion you talked about three things. You talked about a fiduciary relationship, but they really don't say that. What they tell you is you said there was a duty and we have a duty. They don't say they have a fiduciary duty. They don't say they have an undivided duty of loyalty. In Forgion you said there's a confidential relationship. Well, guess what? We have a confidential relationship, we have a privilege. And they say there's a limitation on substitution. Well, we can't just go out and substitute ourselves. But again, the analysis fails because the leading case in the country was Goodley versus Wank and Wank. And when you look at Goodley, which was dealing with the issue of the assignment of a legal malpractice claim, what the court said is the attorney cannot delegate his responsibility to another without the permission of the client. What the Goodley court was addressing was the principal agency fiduciary relationship that exists between an attorney and client. So what KPMG wants you to do today is to say, well, we've got a privilege, we've got one of the three really, so we're just like lawyers, and therefore the same policies don't apply. But the simple answer is that when you go deeper into the analysis, the fact of the matter is the policies that have been historically cited by the courts just aren't present here today. The closest case in this country on point is, I'm sorry, Your Honors, First Community Bank and Trust versus Kelly Hardesty and Smith. They were presented with the same exact factual scenario. There was an accountant-client privilege in the state of Indiana, and the court dissected the actual policy considerations and said they're just not present in this scenario. Other courts have noted, Piccadilly Inc. versus Graco addressing the assignability of legal malpractice claims have noted that assignability is now the rule of law and that the exception is legal malpractice claims because of the close, personal, and highly confidential relationship. KPMG has argued to this court as well that this case presents a classic scenario. The fact of the matter is this case doesn't present a classic scenario of why there shouldn't be an assignment. Bank Atlantic is a sophisticated commercial entity. It bargained for its rights to be paid. It gave away certain rights. In its giving away those rights, in the settlement agreement, it specifically addressed the privilege. It knew the risks associated with losing the privilege or that there could be a loss of privilege. So this isn't a situation where there's been some involuntary loss of right and a client has suddenly been shocked by going, oh, confidential communications I have with my lawyer are being disclosed now and I didn't know it.
Well, was this issue raised about, I realize that we're here on a broader issue, but the question of the fact that certain causes of action against certain entities, Bank Atlantic by this agreement agreed to bring, and specifically this was not in there. Was that raised below? How do we...
The fact of the matter is, Your Honor, there's nothing in the record that indicates that Bank Atlantic said we don't want you guys to bring a cause of action on our part. And we specifically put in our brief without record citations. What you see when you look at the record in this case contained within the covenant not to execute is a discussion of the assignability of the claim. What you see is a discussion about the accountant-client privilege. You don't see any strong-arm extortion between National Union, another sophisticated commercial entity, strong-arming Bank Atlantic, another sophisticated commercial entity. So the fact of the matter is, any argument there of this being a classic scenario just is not present in this case. Your Honors, I'd like to sum up and simply say to this court that what the courts have historically looked at in refusing to allow the assignment of legal malpractice claim has been the close, personal, highly confidential relationship between attorney and client and the undivided duty of loyalty. The confidentiality an attorney owes his client is an absolute necessary for the attorney to fulfill his duty to the client. The CPA's confidentiality is created by statute. The attorney-client privilege is the oldest privilege known to common law. The CPA privilege is created by statute, not recognized at federal law, recognized only a limited capacity finally by statute at federal law in tax cases, in which the courts have said in civil tax matters we will now recognize some degree of privilege. KPMG has not said to this court, they've not undertaken the responsibilities of an attorney. They're not a participant in the adversarial system of justice. They've not demonstrated that the privilege is necessary for them to fulfill their duties and how their relationship will ultimately be chilled or their ability to carry out their function will be chilled. The simple fact of the matter is that the relationship between attorney and client and independent auditor and CPA is fundamentally different. And the policy considerations that preclude the assignment of legal malpractice claims are just not present in the context of the independent auditor CPA. Thank you, Your Honors.
Thank you, counsel. Rebuttal?
Thank you, Your Honor.
Counsel, can I ask you one question? Is opposing counsel correct when he says that should we rule, as you suggest, that we would be the only court in the nation to do so? And if that is true, then why do you think that's true?
Your Honor, we did not present to you a ruling by an appellate court of another state to the effect that we're urging here today. But there is a reason for it. There are, and it's the reason why you should rule in favor of KPMG in this case. Florida is one of the few states in the United States that in fact has an accountant-client privilege. Therefore, the issue has not gone up to this level. The only case cited by the other side, which they say is on all fours with this case, is the Indiana case, the community bank case. But you have to read that case and understand the basis for the court's ruling. And I would like to discuss it with you, because it highlights the differences between Indiana law and Florida law. In the First Community Bank versus Kelly case, directors who had served on the board of directors of the bank agreed to buy certain non-performing loans from the bank. The critical factors that led to that court's conclusion are the following. The transferees were never in an adverse position to the bank. Well, National Union got sued by Bank Atlantic and counterclaimed. The transferees didn't just take the malpractice case, they took assets which put them in the shoes of the transferor. National Union didn't buy any assets from anybody, it didn't get transferred any assets. The malpractice claim itself was not the asset being transferred. In this case, it's the asset being transferred. And finally, that the transfer constituted a waiver of the privilege as to the asset sold, and the trustees, because they had a right to undertake due diligence regarding the quality of those assets, they could take. So the answer to your question is yes, and the Indiana court did not find that despite the existence of a privilege in that state, clients are free to assign and transfer. They said only when it's in connection with the sale of an asset.
Well, your primary reliance then is upon the uniqueness of Florida's privilege. Is that what you're saying?
And Florida's historic treatment in the case law regarding the attorney-client privilege, and please let's take a moment and talk about it. Let's start again with Chief Justice Harding's opinion in Forgion. The language used to determine that an insurance agent did not enjoy the same personal relationship with his client as a lawyer was that there were substantial differences. Can we say that there are substantial similarities under Florida law between accountants and lawyers? Well, certainly the courts in this state for years have uniformly found that. In Peat Marwick versus Lane, which was an accounting tax case before this court in 1990, the court held, we find that the basic principles for all professional malpractice actions should be the same, absent clear legislative intent to distinguish certain professions, in that case, in the application of the limitations period. The third district in Coopers and Library, and you'll note in the third district opinion there is not mention of these lines of cases and no mention of the fact that there's a substantive statutory right beyond just the evidentiary privilege. that in this state, a client has the right under Chapter 473 Florida statutes, which has been construed by the courts to be a substantive right to protect confidential communications with an accountant. The courts have recognized in this state that that gives rise to a private cause of action by the client against his auditor for violating the privilege and releasing confidential communications.
Is there a fiduciary relationship?
Institutionally, KPMG has taken the position, Your Honor, that there is none. However, if you read the Coopers and Lybrand Third District case, there are instances in this state where courts have found a fiduciary relationship. I might add that
you agree that that either is the law or should be the law, that there is a fiduciary relationship, and that the duties and obligations that flow from that flow with reference to
I do not believe that there is a fiduciary relationship in the traditional sense of the term, notwithstanding the fact that the Danler court, which we ask you to disapprove, did say that there was a relationship of trust and confidence between an accountant and his client. But understand, I do not read the opinion in Forgion as to say that you are handing down a bright line test that every profession must meet these standards, because I can tell you that analysis wouldn't stand up in a domestic violence counselor victim lawsuit if a claim for malpractice against that individual was assigned.
You need to bring your remarks to a close.
Yes, sir. That would never survive the test that the other side suggests. They can't prove they're like lawyers. The question before the court is whether or not this is a transfer of a personal tort. I urge the court to bear in mind that this decision affects not just KPMG, but as I said, every accountant in the state of Florida rendering accounting advice to a client, and that the client does not understand these task-based differences in the dialogue they have with their accountant. You should answer the certified question in the negative, quash the opinion of the Third District Court of Appeal, and thereby reinstate the final judgment of the trial court. Thank you very much.
Thank you, counsel. We'll be in recess for 10 minutes.
Please rise.
Of the Florida Supreme Court. The court hears oral arguments the first week of every month. Live coverage of the Florida Supreme Court is also available on the internet at wfsu.org/gavel-to-gavel.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.